Hi, I'm Ralph Tiergart. I'm Vice President for Education at AHOA, and I have the opportunity to welcome you to another Learning Series webinar. We thank you for joining us today. Because we want everyone to be able to participate, on your go-to platform, you'll see a control panel, and it'll look something like this, the mark there. So throughout the presentation, we encourage you to find that control and type any questions you have in. We are going to take questions at the end of the webinar to allow us to get through all the material, but we will handle all the questions you might have. And so without further ado, what I'd like to do is welcome our guests, Raja Patil and Michael McGee, to the program today. They're with Dentons, and they look forward to talking to us all about the new Corporate Transparency Act. So, gentlemen, if you'll introduce yourselves, I'll drop off and look for questions, and we'll reconvene toward the end. How's that work?
That works great. Thanks, Ralph, for that warm introduction. As Ralph mentioned, my name is Raja Patil. I have my partner and colleague, Michael McGee. We're partners at the Dentons Law Firm. Dentons is the world's largest law firm with nearly 6,000 lawyers and professionals across more than 160 offices in over 80 countries. In the United States, we have more than 1,300 lawyers across 44 offices. And people are also surprised to hear that we have 150 lawyers and professionals in 5 of the 6 largest cities in India, and are the first global law firm to have offices in India as well. We are the first polycentric global law firm, meaning that we have no single headquarters and no dominant national culture. Our law firm provides the best of both worlds, local connections and relationships combined with national and global resources. There's a multitude of reasons why clients choose Dentons that I'll briefly run through. First and foremost, we strive to be value-added partners who are industry experts. We have a number of Chambers Band 1 attorneys, and our hotel group has received numerous accolades, including Law 360 Hospitality Group of the Year a few years ago. Michael and I are situated in Louisville, Kentucky, and we conveniently keep our billing rates multiples less than other attorneys at large law firms, and even offer discounted rates for AHOA members on legal services. We have broad expertise in industry knowledge and a client-focused approach to our legal services. We represent a broad mix of clients that come from virtually every corner of the hospitality industry, including owners, family offices, REITs, and high net worth individuals. And we strive to form long-term relationships with our clients to the point that Michael and I are typically serve as outside general counsel to most of our clients for all of their legal needs. We have a long-term commitment to the hotel industry. And as mentioned before, we have industry partners across the country and the world to draw upon. Bottom line is Dentons is a one-stop shop for all your legal needs, and we hope to be the first attorneys you call no matter what legal issues come your way. So thank you for allowing us the time to generally discuss our firm. But let's turn attention to cover the very important topic of the Corporate Transparency Act, which will affect virtually everyone listening to this seminar. So without further ado, let me turn it over to my partner and colleague, Michael McGee. Michael, take it away. Thank you.
Sure thing. Good afternoon, everyone. It's good to be with you. As Raja noted, we're going to talk about the Corporate Transparency Act today. I would guess that a lot of you probably have not heard about this, even though it was passed nearly 3 years ago. As Raja noted, we expect that this act will have sweeping impacts on business owners throughout the U.S. So we just generally want to talk about the requirements as well as some of the questions that remain unanswered as of today. So as I noted, the act was passed by Congress in January of 2021. It's intended to combat money laundering, tax fraud, financing of terrorism, and similar crimes. And the crux of the statute is that it requires certain business entities, and I'll get into this later, but it is very much an entity by entity analysis, to report information on their beneficial ownership, as well as to disclose information about the person who actually created or registered the entity to do business in the US. It is noted below, FinCEN, which is the Financial Crimes Enforcement Network, which is a part of the US Department of Treasury, released its final rule implementing the CTA last year. But again, there's still a lot of questions that remain unanswered at this stage, which we'll get into later. Next slide, please. So first question, you're probably asking yourself, okay, well, who is subject to this statute? And there are two categories of entities that are covered by this statute, and as you'll see, it has a very broad reach. So again, as I noted previously, the analysis is done at an entity by entity level, and again, two general categories of business entities that are covered. So the first is a domestic reporting company, which is essentially any entity. It could be an LLC, it could be a corporation, a limited partnership, anything that you would have to file organization documents with your state secretary of state or any secretary of state, as well as any similar office under the jurisdiction, any tribal jurisdiction. If you have registered with any of those types of authorities and formed your business in that manner, you may be subject to these reporting requirements. There's also the Act also covers what are called foreign reporting companies. And these are any entities formed under the laws of a foreign country that, despite being formed abroad, is also registered to do business in any U.S. state or tribal jurisdiction, again, by filing some sort of qualification document with the Secretary of State or similar office in the U.S. So very broad reach. It obviously covers both domestic companies that are doing business in the U.S. as well as potentially foreign companies that are doing business in the U.S. Next slide, please. So again, the statute has a pretty broad reach, and you may be asking yourself, well, geez, that seems pretty broad to me. Hopefully there's some exceptions or exemptions that might apply to me, so I don't have to follow these reporting requirements. There are numerous exemptions set forth in the statute. Unfortunately, many of them apply to entities that are already regulated by another regulator, such as the FDIC or the SEC. So things like companies that are public and have registered with the SEC, investment companies, venture capital advisors, insurance companies, banks, who are typically regulated by the FDIC or similar regulatory agency. So those types of entities are exempt from the reporting requirements because they're typically already subject to reporting requirements promulgated by those other agencies. Since we're talking about the hotel industry, generally speaking, we're not expecting many of these exemptions to apply here. I think one that potentially could apply to, if you can click over to the next slide, Ralph, please. One that could potentially apply to some hotel owners, hotel managers, et cetera, is an exemption to reporting that covers large operating companies, is what the statute refers to them as. So in order to qualify for this exemption, there are three things that you would have to satisfy. And again, if you satisfy all three of these elements that are listed on the slide here in bold, you are exempt from the reporting requirements. So I'll touch on those now in turn. So first criteria is that the entity must employ more than 20 full-time employees in the United States. And under the rules, a full-time employee, generally speaking, is considered someone who works an average of at least 30 hours a week. Importantly, the exempt reporting entity must be the employer. So under this factor or this criteria used as part of this exemption, you can't consolidate employees that may work for affiliate entities. And so, for example, a parent company can't count employees of its subsidiaries or vice versa. This analysis is very much done on an entity by entity level. The second factor, the entity must have an operating presence at a physical office within the United States. It's fine if the office is owned or leased, so you don't have to own the office where you're actually doing business within the US. Just having a lease would be sufficient. What you can't do is, find some mailing address, share it with some other entity, solely for purposes of having an address to avoid the need of being subject to these reporting requirements. That is not permitted under these rules. They don't want ghost offices set up, I guess is what I would call them. So again, it has to be a distinct place of business, unaffiliated with any other entity. And then lastly, the entity must have filed a federal income tax return in the United States during the previous year, demonstrating more than $5 million in gross revenues. And that is net of returns, allowances, and similar adjustments. So as noted on the slide, this is US only income. So to the extent, and I think this is probably unlikely, but to the extent that there is foreign income flowing into the entity, that is not that is not considered as part of this analysis. And then as noted here on the slide, and this is different from the first factor where we're talking about employee headcount, an entity that is part of an affiliated group of corporations and that files a consolidated tax return, that covers multiple entities, you may use that amount that was reported on that consolidated tax return to establish that $5 million gross receipt or gross sales threshold. So again, that is a little bit different from the employee headcount analysis. So as I noted, this is probably the exemption that's most likely to apply to AHOA members, but I think there are probably some factors that may, ultimately lead to this exemption not applying for many members. For instance, I know meeting with AHOA members at AHOACon, I know that there are quite a few members that may only have 1, 2, or 3 hotels. So in that instance, you may have trouble satisfying either the headcount requirement or the revenue requirement. And then, similarly, even if you do have a larger portfolio of hotels, we're used to seeing typically that those are owned through separate entities, owned and operated through separate entities. So again, since the employee headcount analysis is done on an entity by entity level, even if you have a larger portfolio, but you're operating those through multiple LLCs or corporations, that could potentially cut against your ability to rely on this exemption. But again, we do believe that this is the exemption most likely to apply to AHOA members. Next slide, please. Okay, so we've talked about, who the statute applies to. We've talked about potential exemptions to reporting. Assuming that you are a covered entity, that you're not able to find any sort of exemptions to reporting. These next couple slides are going to address exactly what does need to be reported to FinCEN. So there are 2 things, generally speaking, that need to be reported. So the Act requires that any companies created or registered on or after January 1st of 2024 disclose information regarding their beneficial owners, as well as the what's called the company applicant. So the first person who must be, or group of persons who must be reported, again, are beneficial owners. And so this is anyone who either exercises substantial control over the reporting company, or owns or controls at least 25% of the ownership interests in the reporting company. And that is either direct or indirect ownership. I guess that's not noted on the slide, but it goes, they want to go all the way up to, individual ownership, whether that's direct or indirect. So the ownership, requirement's pretty easy. It's pretty easy to figure out whether someone owns 25% or more of the ownership interest of the reporting company. What's not as clear cut is what constitutes substantial control, because again, they don't even need to be an owner. If someone exercises or has the power to exercise substantial control over the reporting company, you've got to report information regarding those people as well. So according to the rules that have been issued, substantial control is a factual inquiry, and it's not necessarily determined by what title a person may have, for instance. And so there are some examples given in the rules that I'll list out, that may be helpful as you run through this analysis. So if someone has authority over the appointment or removal of senior officers of the entity, or has the power to appoint or remove a majority of the board of directors, or if there's a similar body, governing or that manages the entity, that may constitute substantial control. Or just if someone generally directs, determines, or has substantial influence over important decisions made by the reporting company, including things like the nature and scope of the business, the sale or lease of assets, major expenditures or investments, issuance of additional equity or ownership, incurring debt, selection or termination of new business lines or ventures that the entity may engage in, approval of an operating budget, entering into or terminating significant contracts, or amending the company's governing documents. If someone has the authority under the organizational documents of the entity or otherwise to do any of those types of things, they may in fact have what's referred to as substantial control, and you may need to provide information about those persons, again, whether or not they actually own the equity of the entity. And then the other category of person that or that the entity has an obligation to report upon, and in this case, it is only for companies formed after January 1st of 2024, is information regarding the company applicant, who is essentially the person who filed the necessary paperwork with the Secretary of State or other governmental authority to do business within the U.S. Significantly, this includes, any attorneys that may have been involved in that process, paralegals who may have been involved in that process. So it's a pretty wide-ranging definition there. Next slide, please. Okay, so what actually needs to be disclosed about these categories of people? So for both beneficial owners and company applicants, the entity must disclose the person's full legal name, their date of birth, their address, a passport number, a driver's license number, or other unique identifying number from a non-expired identification document issued to the individual by a state for identification purposes, such as a picture ID. So, and then you're also required to submit a copy of that identification number. So if you're submitting your passport number, you need to submit a copy of the person's passport. If you're submitting a driver's license number, you need to submit a copy of a driver's license, et cetera, et cetera. Next slide, please. And then also, the company is required to disclose information about the company itself. So that includes its full legal name, any trade names or DBAs, whether or not those have been registered, its address, its jurisdiction of formation or registration in the US, and then its tax identification number, which is either going to be an EIN, or if it's an entity that's only owned by one person and it's disregarded for tax purposes, that may end up being the 100% owner's social security number. But some sort of tax ID number does need to be disclosed. Next slide, please. So you may be asking, okay, well, if I form a new entity and I submit the report as required, am I done, or is there some sort of continuing obligation under the statute? Unfortunately, it's not a one-shot deal here. Under the final rule, a reporting company must file an update to its report within 30 days after the occurrence of any change affecting information in its the report that it previously filed. So, for instance, if there are any changes with respect to beneficial owners, changes in addresses, changes in names, changes in where you are registered to do business, anything set forth on that initial report that changes, you are in all likelihood going to need to update FinCEN with any of those types of changes. Next slide. Okay, so one thing we also wanted to touch on is the fact that there are consequences for not reporting. In the grand scheme of things, I suppose these penalties are not the worst that maybe you've ever seen, but they are significant. So certainly someone who is aware of these reporting requirements and decides that they don't want to comply, that may not be the wisest choice. As you'll see, the Act provides for both civil and criminal penalties. There is a maximum civil penalty of up to $500 per day, up to $10,000 in the aggregate, as well as imprisonment for up to 2 years. So there are, again, significant consequences that are provided for under the Act for entities that do not follow these reporting requirements. Next slide. In terms of timetable, I think at the outset of the presentation, we noted that this is something that is coming into play really soon. In fact, just a little over a couple months from now. So the Corporate Transparency Act goes into effect on January 1st of next year, and there is kind of a bifurcated approach that is set forth in the Act based on when the business entity was formed, in terms of when you have to file a report for that entity. So for any reporting companies that are created or formed before January 1st, 2024, those companies will have a year to comply with the reporting requirements. So their initial reports must be filed by January 1st of 2025. So if you have, business entities that exist as of today, or they're created before January 1st of next year, you will have until January 1st of 2025 to file the necessary reporting paperwork. For any entities formed on or after January 1st of 2024, however, they must comply with the disclosure and reporting requirements within 50 days of formation. So if you happen, for example, to form a new entity on January 1st of next year, you would have to submit all of this information to FinCEN by January 31st, or 30 days after formation. This is noted on the next slide, but I'll touch on this quickly and stay on this slide. There is a potential amendment that has been proposed that would give a company 90 days to report for companies formed on or after in calendar year 2024 instead of 30 days. But that has not been yet formally adopted, and that does not change the reporting timetables for entities formed before January 1st of 2024 or entities formed in 2025 or after. But I did want to mention that potential change. And then the last bullet point on this page, it may be hard to believe, and I think a lot of us in the legal profession are sitting here pulling our hair out over this, but the reporting system has not yet been released by FinCEN. It's still under development. So it's really anyone's best guess as to exactly what this reporting platform is going to look like, exactly what that process is going to be, its functionality, etc. So, I think there are lots of people eagerly waiting for updates on that, certainly. But that is yet to be addressed by FinCEN. Ralph, if you want to go to the slide after the next one, actually, because I touched on this one. Thank you. So then the last thing we wanted to touch on as part of this presentation, you may be asking yourself who will see this information. I won't go into each and every detail I get set forth on this slide, I guess, but generally speaking, federal agencies may see this information, state and local law enforcement agencies, financial institutions, federal and state regulators, officers, employees of the Treasury Department. So those are the categories of people that may see this information. You'll note in a couple instances, for instance, with respect to state and local law enforcement agencies, those agencies are required to provide a court order before they can access your information. Similarly, with financial institutions, they're only allowed to access information if the reporting company provides its consent to that information being accessed. So there are some guardrails here, but still there are several categories of people who may have access to this information. The final bullet point on the slide here, FinCEN has stated that it intends to issue additional rules that provide additional safeguards and restrictions on the exact individuals within these different types of agencies or businesses that may see the information, how they can access it, what they can do with it. But again, those rules are still in the works and have not been released as of today. Okay, and I think that was the final slide in the presentation, yes. So if anyone has any questions this time, we're happy to answer.
Michael, that was great. We do have some questions. I'm taking a look at one now. It appears that all the information FinCEN's requesting under this rule already exists within each state where corporate reports are filed. So the one thing additional that they're asking looks like it's the photo ID. The corporate report already has beneficiary name, address, social, and FEID. It appears redundant information that already exists within each state agency. Could you address that, please?
Yeah, I agree that in some states, a lot of this information may be duplicative, but the rules do vary state by state in terms of what must be reported, what is publicly available, et cetera, et cetera. So I agree that there is some overlap, but I think that there are some categories of information picked up in these reporting requirements that, certain people in certain states, these may be completely new requests for them. So I think it is very much a state-by-state analysis.
Another thing, Michael, is that you talked a little bit about the reporting requirements for entities formed after January 1st, just for clarity's sake. the reporting requirements for entities that can't prove an exemption status form before January 1st. You are suggesting in this presentation that this reporting requirement applies to them as well?
That is correct, but they have a little bit, not a little bit, they have a year of extra time to file those reports. So if you have an existing entity or you end up forming an entity between now and the end of the year that it turns out is not exempt and is subject to these reporting requirements, as long as it's been formed again before January 1st of 2024, you have a year, so until January 1st of 2025, to file your reports for those existing entities.
Okay, thanks. Now,
Sure.
Michael, this is something from my own background, having worked for a large management company. In the slide in which you talked about exemptions and corporate entities, would it be your supposition that a majority or some percentage of management companies that do third-party management that meet all the physical requirements would likely achieve that exemption? Or have you thought about from a third-party management perspective, in how many cases are those folks also going to have to think this through on behalf of their clients?
Yeah, I think, honestly, the analysis from my perspective with respect to management companies versus, hotel owners or hotel owners / operators, I think they're quite similar. I think it's really just going to be kind of an entity by entity analysis for all of those types of businesses. I am glad that you brought up management companies, because one of the things that people may want to start thinking about, to the extent that you do have third-party managers for your hotels, is delineating in your management agreements, to the extent that this is possible, who is responsible for reporting requirements with respect to both the owner and the manager entity, and making sure that that's all properly covered as part of the management agreement. So that is something I wanted to mention, because that is something that people may want to start thinking about, is what do we need to put in our management agreements to address these reporting obligations.
All right, good. I do see a question here. You used the word beneficial owner. Could you explain that again, please? What is beneficial ownership?
Sure. So beneficial owner is, and let me go back to my language here to make sure I'm getting the language 100% correct. But a beneficial owner is, the easy, there's two categories of people that may be a beneficial owner. So the first is easy. It's anyone who owns or controls, and that's, again, either direct or indirectly, at least 25% of the ownership interest in the reporting company. So typically that's pretty easy to figure out, whether someone is at 25% or above ownership in a company, again, whether that's direct or indirect. The second bucket of beneficial owners includes anyone who exercises substantial control over the reporting company. And as I mentioned earlier, unfortunately, that is not as clear cut of an analysis. It is very fact-based, and it really boils down to whether someone has significant say in how the entity is managed, operated, etc. Whether that's through appointment of officers or management, or appointment of board members or members to a board of managers, or whether they have a direct say in things like involving key business decisions. So again, incurring debt, sale of assets, significant expenditures. If someone has a say in those types of things, then they may in fact be a beneficial owner. But again, it's going to be a fact-based analysis that really is going to have to be looked at on an entity by entity basis.
Okay, that's so just as a follow-up for me on how you just explained that. So it sounds like more limited owners that are more from an investor standpoint, and have investor ownership at a more limited level, who don't have those controlling attributes in the relationship, that would probably not apply to them. Is that how you see it?
Yeah, again, it's not necessarily a black or white answer, but yes, just generally speaking, a lot of times what we'll see with, more passive investors or limited partners is that they don't have as much of a say kind of in the overarching management of the business. So it's, probably a safe assumption that someone who is, in fact, a more passive investor probably is not a beneficial owner. Again, as long as they don't meet the 25% ownership requirement as well. But I think that's generally a safe assumption.
Okay. A question came in. When can we start reporting, and what would the link be for that?
Yeah, good question. So my understanding is, and again, that this could change, but my current understanding is that this reporting portal, and it will be an online portal that will be hosted by FinCEN, but that it will not be live until January 1st of next year. So you cannot submit your reports until January 1st rolls around. And then I think that the second part of the question was about timing.
The link, and the link. So the link.
I'm sorry.
The link doesn't exist
yet.
Yeah,
the link unfortunately does not exist yet. That's
okay.
Right.
Okay. And I guess I have a final question here. The genesis of all this is this somehow still stem from 9/11? What are some of the other factors for this coming into play now?
Yeah, I think that's probably part of it. I think, part of it is, maybe driven by concern over foreign investment by, investors from certain countries that are on the United States radar. And as of right now, there's not really a central repository anywhere where ownership information is, disclosed and retained. So the idea is, a lot of times, and frankly, we have clients that do this, under the current, structure without the statute being in place, a lot of people are able to remain anonymous in terms of their association with a business, for instance, by setting up shell companies, setting up in states where the disclosure requirements are not as robust. So Delaware is a good example. There's not a lot of information that's made publicly available for entities that are located in Delaware. So I think the idea is just to, again, prevent the use of shell companies or front companies to disguise investment from people that, the Department of Treasury and other law enforcement agencies may want to have on their radar.
Awesome. So I had another comment come through expressing appreciation on behalf of AHOA EDU, Michael and Raja both, for your information today. It's incredibly important. And I know that we're all going to be watching this very closely and quite likely revisiting this with additional information updates for our membership after January, when they settle things like to whom do you report and what portal and what link and et cetera, et cetera. So this is something we'll watch closely and continue to provide information on. I want to thank you both. I want to thank everyone in the audience who's joined us today. We will publish this webinar to AHOA.com along with all other Learning Series webinars. So thank you for doing this. We look forward to hearing from you guys again, and hope everyone has a great weekend.
All right. Thank you, everyone.